The Negotiable Instruments Law. 3. Negotiation. Section 30. What constitutes negotiation? An instrument is negotiated when it is transferred from one person to another in such manner as to constitute the transferee the holder thereof. If payable to bearer, it is negotiated by delivery; if payable to order, it is negotiated by the endorsement of the holder and completed by delivery. Section 31. Endorsement. How made? The endorsement must be written on the instrument itself or upon a paper attached thereto. The signature of the endorser, without additional words, is a sufficient endorsement. Section 32. Endorsement must be of entire instrument. The endorsement must be an endorsement of the entire instrument. An endorsement which purports to transfer to the endorsee a part only of the amount payable, or which purports to transfer the instrument to two or more endorsees severally, does not operate as a negotiation of the instrument. But where the instrument has been paid in part, it may be endorsed as to the residue. Section 33. Kinds of endorsement. An endorsement may be either special or in blank, and it may also be either restrictive or qualified or conditional. Section 34. Special endorsement, endorsement in blank. A special endorsement specifies the person to whom, or to whose order, the instrument is to be payable, and the endorsement of such endorsee is necessary to the further negotiation of the instrument. An endorsement in blank specifies no endorsee, and an instrument so endorsed is payable to bearer, and may be negotiated by delivery. Section 35. Blank endorsement, how changed to special endorsement. The holder may convert a blank endorsement into a special endorsement by writing over the signature of the endorser in blank any contract consistent with the character of the endorsement. Section 36. When endorsement restrictive. An endorsement is restrictive which either a. prohibits the further negotiation of the instrument, or b. constitutes the endorsee the agent of the endorser, or c. vests the title in the endorsee in trust for or to the use of some other persons. But the mere absence of words implying power to negotiate does not make an endorsement restrictive. Section 37. Effect of restrictive endorsement, rights of endorsee. A restrictive endorsement confers upon the endorsee the right a. to receive payment of the instrument, b. to bring any action thereon that the endorser could bring, c. to transfer his rights as such endorsee, where the form of the endorsement authorizes him to do so. But all subsequent endorsees acquire only the title of the first endorsee under the restrictive endorsement. Section 38. Qualified endorsement. A qualified endorsement constitutes the endorser a mere assigner of the title to the instrument. It may be made by adding to the endorser's signature the words "without recourse" or any words of similar import. Such an endorsement does not impair the negotiable character of the instrument. Section 39. Conditional endorsement. Where an endorsement is conditional, the party required to pay the instrument may disregard the condition and make payment to the endorsee or his transferee whether the condition has been fulfilled or not. But any person to whom an instrument so endorsed is negotiated will hold the same, or the proceeds thereof, subject to the rights of the person endorsing conditionally. Section 40. Endorsement of instrument payable to bearer. Where an instrument, payable to bearer, is endorsed specially, it may nevertheless be further negotiated by delivery, but the person endorsing specially is liable as endorser to only such holders as make title through his endorsement. Section 41. Endorsement where payable to two or more persons. Where an instrument is payable to the order of two or more payees or endorsees who are not partners, all must endorse unless the one endorsing has authority to endorse for the others. Section 42. effect of instrument drawn or endorsed to a person as cashier. Where an instrument is drawn or endorsed to a person as cashier or other fiscal officer of a bank or corporation, it is deemed prima facie to be payable to the bank or corporation of which he is such officer, and may be negotiated by either the endorsement of the bank or corporation or the endorsement of the officer. Section 43. Endorsement where name is misspelled, and so forth. Where the name of a payee or endorsee is wrongly designated or misspelled, he may endorse the instrument as therein described, adding, if he thinks fit, his proper signature. Section 44. Endorsement in representative capacity. Where any person is under obligation to endorse in a representative capacity, he may endorse in such terms as to negative personal liability. Section 45. Time of endorsement, presumption. Except where an endorsement bears date after the maturity of the instrument, every negotiation is deemed prima facie to have been effected before the instrument was overdue. Section 46. Place of endorsement, presumption. Except where the contrary appears, every endorsement is presumed prima facie to have been made at the place where the instrument is dated. Section 47. Continuation of negotiable character. An instrument negotiable in its origin continues to be negotiable until it has been restrictively endorsed or discharged by payment or otherwise. Section 48. Striking out endorsement. The holder may at any time strike out any endorsement which is not necessary to his title. The endorser whose endorsement is struck out, and all endorsers subsequent to him, are thereby relieved from liability on the instrument. Section 49. Transfer without endorsement, effect of. Where the holder of an instrument payable to his order transfers it for value without endorsing it, the transfer vests in the transferee such title as the transferor had therein, and the transferee acquires in addition, the right to have the endorsement of the transferor. But for the purpose of determining whether the transferee is a holder in due course, the negotiation takes effect as of the time when the endorsement is actually made. Section 50. When prior party may negotiate instrument. Where an instrument is negotiated back to a prior party, such party may, subject to the provisions of this Act, reissue and further negotiable the same. But he is not entitled to enforce payment thereof against any intervening party to whom he was personally liable.